Good morning. Thank you, Mr. Chairman. I would first of all like to thank the European Law Registries Association for their kind invitation to participate in this conference, and also the Institute for Registries and Notariate of Portugal in the person of its chairman, Dr. António Figueiredo, also for the invitation to be here today. It is a pleasure and an honor for me to participate in your conference. The subject matter of my talk has been announced is the enforcement of foreign deeds in Portugal. The problem that I am addressing in my talk is what are the effects of foreign deeds, that is to say, documents issued by foreign authorities or foreign notaries in this country. I am particularly going to address the problem of determining whether such deeds may serve as the basis of enforcement proceedings in Portugal, and whether they may be used as documentary evidence in judicial proceedings, in the drafting of notarial acts, and in the registration of legal acts in Portugal. Now, as a short note on the relevance of this problem, as surely all of you know, Portugal is a relatively small country with 10 million inhabitants, but what many of you may not know is that Portugal has a large number of immigrants, around 5 million people living outside its borders all over the world. From the United States to China, we have immigrants in every part of the world. And also Portugal is today a country of immigration. We have about 500,000 people living, working in our country. Furthermore, the Portuguese economy is today a very open economy, highly dependent on international trade and foreign investment, as well as is known by everyone, on tourism. So the problem of the enforcement of foreign deeds in Portugal is nowadays a real necessity in a large number of situations in this country. In order to address this issue, one has to take into consideration different kinds of legal sources. In the first place, internal sources. The subject matter of my talk is regulated inter alia by the Code of Civil Procedure of 1961, the Civil Code of 1966, the Code of Land Registry of 1984, and the Code of Notariate of 1995. Several international sources are also relevant in this regard. Portugal is a member state to several CEC conventions, notably those that were entered into in 1956, 57, and 76, which were subsequently ratified by my country. Portugal is also a member state of the Hague Convention on Apostille, which was ratified by this country in 1968, and is also a member state of the Lugano Convention on the International Jurisdiction and the Enforcement of Foreign Judgments and Authentic Acts. European sources also come into play in this regard. Of course, we are bound by the European legal acts that are relevant in this field, notably the Brussels I regulation, recently recast, although the recasting regulation is not yet in force, as you may know. Also, the regulation on the European Enforcement Order for Uncontested Claims, and more recently the regulation on succession matters of 2012. Now, as for the rules that are contained in these different sources that I've just mentioned, there are basically three kinds of requirements that are provided for in their rules. In the first place, the requirement of exequatur, that is to say, of a declaration of enforcement or enforceability that is to be granted by a court in order that a foreign deed may have effects in a given country. Secondly, the requirement of legalization, that is to say, the certification of authenticity of a foreign deed. And finally, the requirement of translation. These requirements are not dealt with identically by the sources that I have just mentioned. I will try to describe succinctly how they regulate these three types of requirements. Starting with exequatur. In Portuguese internal law, the Code of Civil Procedure, in its Article 49, paragraph 2, establishes that foreign deeds may be enforced in this country with the exemption of any previous exequatur, that is to say, no declaration of enforceability is required for this purpose, as long as two requirements are met. In the first place, the deeds in question must fall into one of the categories of enforceable titles that are provided for in Portuguese law. Article 46 of the Code of Civil Procedure contains a list of the types of titles that may be enforced by Portuguese courts, judicial decisions, deeds drafted by notaries, even private documents may be enforceable titles in this country. Portuguese law is rather generous in this regard. Furthermore, these foreign deeds must comply with the formalities that are required by the law of their country of origin. So two laws come into play in deciding whether or not, under Portuguese internal law, foreign deeds may be enforced in this country. You have to apply the Portuguese law, the lex fori, in what regards the definition of which kinds of titles may be enforced here, and you have to apply the law of the country of drafting of the deed in order to determine which formalities had to be complied with by this deed. This rule, contained in Article 45.2 of the Code of Civil Procedure, contrasts with the rule contained in paragraph 1 of the same provision concerning the enforceability of foreign judgments and arbitral awards. In regard of judgments and awards, the Portuguese Code of Civil Procedure requires an exequatur by a Portuguese higher court. In principle, it is a court of appeal that has to give the declaration of enforceability for this purpose. Of course, this provision does not apply insofar as there are international conventions or EU acts that provide otherwise and which are applicable in this country. Now, one may ask, what is the reason for this disparity of rules? On the one hand, we exempt foreign deeds from exequatur. On the other hand, we require such an exequatur concerning foreign judgments and awards. The reason, in part, lies with the arguments that may be opposed by the defendant in enforcement proceedings against these two types of foreign titles. If you have a foreign deed, which did not undergo an exequatur procedure, the defendant may raise in the enforcement procedure all means of defense that are allowed in declaratory proceedings in Portugal. So he has a wide panoplia of arguments that he can raise in those proceedings. Whilst on the other hand, in enforcement proceedings concerning foreign judgments and awards, such proceedings may only be contested on one of or more of the formal or supervening grounds that are provided for in Article 814 of the Code of Civil Procedure. So the number of defenses that are allowed in this case is more limited. This is the counterpart of the requirement of exequatur in this case. Coming now to the Civil Code, Article 365, Paragraph 1 of our Civil Code of 1966 states that authentic documents issued abroad according to the lex loci, according to the law of their country of origin, have the same evidentiary effect of equivalent documents that have been issued in Portugal. And this evidentiary effect includes the use of such deeds as evidence of facts that have occurred abroad and which are to be registered in Portuguese land registries. So, again, no exequatur is required by Portuguese law for the purpose of the deployment of effects by foreign deeds for these purposes. Now, a word on European law in what concerns exequatur. As surely most of you know, Brussels I regulation requires an exequatur for the purpose of the enforcement in a member state of the European Union of documents drawn up or registered as authentic documents in another member state. And the Lugano Convention states exactly the same rule. The European Enforcement Order regulation has gone a step beyond in this regard. It exempts exequatur in what concerns instruments that have been certified as European enforcement orders in their member state of origin. Of course, the number of titles that may be certified as such is very limited. It is basically uncontested claims that are at stake here. The Brussels I recast regulation has changed the applicable rule in this regard, as it has abolished exequatur of foreign judgment and also of foreign authentic instruments. But this recast regulation, as you know, is not yet applicable. It will only be applicable as of 2015. Also, the successions regulation exempts from exequatur authentic instruments in what concerns evidentiary effects, but in what concerns enforcement of such instruments, exequatur is still required by this new regulation. I now come to the issue of legalization of foreign deeds. Legalization is provided for also in our Code of Civil Procedure. Article 540 states that documents issued abroad are deemed to be legalized if the issuing authority's signature is recognized by a Portuguese diplomatic or consular agent, and this agent's signature in turn is authenticated with a seal of the consulate or of the Portuguese embassy abroad. Now, for enforcement purposes, legalization of foreign documents is in principle required in Portugal unless, according to our doctrine, such documents are manifestly authentic. So, in any case, legalization may be, on these grounds, exempted. But for evidentiary purposes, Articles 365, Paragraph 2 of the Civil Code and 44 of the Code of Notariate only require legalization of foreign documents in Portugal if there are reasonable doubts concerning their authenticity. So again, Portugal here is rather liberal in what concerns the effects of foreign documents. The situation is somewhat different in what concerns international and European law in this regard. In international law, the CIEC conventions that I mentioned a few moments ago have abolished the requirement of legalization in what concerns certain categories of public documents concerning civil status. But the number of documents that are affected by this rule is extremely limited. The Hague Convention of 1961 has, as you know, replaced legalization by an apostille, which is to be placed on the document at stake by an appointed authority, and this apostille proves the authenticity of this document. Finally, concerning European law in regard of legalization, we are now faced with an important proposal coming from the European Union the proposed regulation on promoting the free movement of citizens and businesses by simplifying the acceptance of certain public documents in the European Union, which has been recently published as document COM 2013-228 of 24 April this year. Now, this proposed regulation exempts documents issued by public authorities of member states from legalization and similar formalities such as the apostille. So we will move a step beyond the Hague Convention of 1961 if this regulation is approved. Where a reasonable doubt arises concerning the authenticity of these documents, a request for information may be submitted to the issuing authority. So this regulation, or this proposed regulation, is based on some kind of trust among public authorities of the member states in regard of these problems. This is an important measure. It is part of the 2009 Stockholm Programme on an open and secure Europe, serving and protecting citizens. We will see if it comes into life. Finally, in what concerns translation of foreign deeds, here we have to take into consideration, inter alia, our Code on Land Registration. Article 43, paragraph 3 of this code currently exempts from translation foreign documents that have been drafted in English, French, or Spanish, as long as the competent civil servants that has to carry out the registration dominates these languages. This is one of the so-called simplex measures that were introduced by the Portuguese government in 2008, aimed at reducing the red tape in Portuguese public administration. So translation of foreign deeds is not required by Portuguese land registries as long as they are those documents are issued in one of the aforementioned languages. The proposed regulation on the acceptance of public documents in the European Union also contains a rule in this regard. It states that authorities shall accept non-certified translations of public documents issued by authorities of another member state if there is a reasonable doubt as to the reliability of the translation provided. Then a certified translation may be required. So translation requirements are not exactly abolished by this regulation, but they are somewhat mitigated. Now another question arises, which is how these rules interact. How should Portuguese authorities combine these different rules that I have just described? Well, according to Article 8 of the Portuguese Constitution, international and European law prevail over internal law. So whenever you have an international or European rule that applies to a given subject matter, it has precedence over internal rules. So this means that in some cases, exequatur of foreign deeds that originate from other EU member states may be required in Portugal, even though Portuguese internal law does not require it in the specific case. This is exactly what has found out our Supreme Court in a judgment that was rendered on 16 June 2005, in which a deed issued by a German notary in Hamburg was at stake. Its enforcement had been requested before Portuguese courts. No exequatur was required by Portuguese internal law, by our Code of Civil Procedure, but Brussels I regulation, which applied to this case, did require such an exequatur, and the Supreme Court decided that since such exequatur had not been previously obtained, this German deed could not be enforced in Portuguese courts, although if Portuguese internal law only applied, that would not have been a problem. So what conclusions may one draw from what has been said so far? Well, the first note that I would like to underline is that clearly there is a trend in the European Union nowadays to exempt or to mitigate exequatur proceedings, as well as legalization and translation requirements in regard of deeds that originate from other European Union member states. So the direction that the European Union is following now is clear one to simplify the enforcement of foreign deeds. But this is not something exactly new for Portuguese law. Portugal has in fact anticipated this trend in some cases by several decades. Since 1961 we have had rules that exempt exequatur in what concerns foreign deeds. Now, the paradox of this situation is that due to the prevalence of European Union law in our country over internal law, it may in some cases nowadays be more difficult to enforce European Union deeds than non-European deeds, because those non-European deeds will benefit from our internal rules that exempt them from exequatur, whilst if there is a EU deed at stake, they will have to comply notably with the Brussels I regulation requirements. There is nevertheless some hope in this regard, because I think the most recent developments in European law may, I think, bring this paradox to an end if, in fact, the Brussels recast regulation will enter into force, and if this new draft regulation on the acceptance of foreign documents will be approved by the European Union. So I finish with this note on some hope that things will improve in our country in this regard. Thank you very much for your attention.
Thank you, Professor. Are there any questions? Yes?
For this presentation, I have two questions. One is not very serious, concerning Article 43 of the Code of Land Registries. Is there any chance to have also deeds in German language one day integrated in the Portuguese system? The second question is more serious, concerning the interpretation of Article 365 of the Civil Code. You made a distinction, if I got it correctly, between, on the one hand, notarial deeds in general and more specifically authentic instruments. So if I got you right, this presumption of equivalence in Article 365 of the Civil Code only applies to authentic instruments according to the Unibank decision of the European Court of Justice, but does not apply to private documents and not apply to notarial documents coming outside the area of the Unibank decision of the Court of Justice. Is that right?
Yes. Thank you for your questions. As to the first question, I would say that whether or not German language will be also be contemplated in this exemption of translations may to some extent depend on Germany itself. I believe that German is not very widely spoken among our civil and land registrars, and that may be the reason why it was not included in those languages which benefit from this exemption of translation. But who knows whether the Goethe Institute will do something about this in the future in Portugal. Now, as for your second question, I think maybe I was not sufficiently clear, but our Article 365 of the Civil Code exempts from exequatur both authentic and private documents that have been drafted in foreign countries according to local law. So they may be used in Portugal for evidentiary purposes, just as documents drafted and issued in Portugal would be. So there is no difference between authentic and private documents in this regard in our law.
Okay. Other questions? Thank you very much, Professor.